Good afternoon, everybody, and welcome. This Oversight Committee and this Subcommittee on Disability Assistance and Memorial Affairs will now come to order. Throughout the past year, members of the subcommittee, as well as the full committee, have heard from VA representatives on various initiatives that have been instituted in order to fulfill the Secretary's goal on disability benefits claims for 2015. VBA implemented national initiatives within its regional offices, including challenge training, quality review teams, skill certification testing, and simplified notification letter, and fully developed claims. VBA also rolled out new technologies in the form of the Veterans Benefits Management System and several other electronic projects, as well as new processing model for featuring segmented lanes and cross-functional teams. All along, VBA indicated that significant support and training from VBA Central Office would be critical in this rollout. On top of these challenges, in April of 2013, VA announced that all cases pending in excess of 1 year would be completed by the conclusion of fiscal year 2013. Based on this new push, VA instituted many months of mandatory overtime for its employees. While there are general concerns on whether VA employees were able to issue decisions of high quality within the expedited time frame, there are also concerns that many of these oldest claims, in fact, were highly complex. Regional office employees have previously reported that claims processors would pass over difficult cases and would routinely decide to call easy claims first in order to meet the production goals and maximize workload and workload credit parameters. Thus, it would stand to reason that many of these 2-year-old and 1-year-old claims decided in the past quarter constituted a challenging workload. And today we'll hear about a focus issue which ties into the VA's various initiatives and which highlights the clear necessity of uniform central office support and thorough employee training. Today's focus is upon the complex claims that are routed to the special ops lanes at the regional office, to include large multi-issue claims as well as traumatic brain injury, post-traumatic stress, military sexual trauma, and claims involving special monthly compensation, just to name a few. While VA reported in November of this year that complex claims which take an excessive time to require special handling or only constitute 10% of VA's workload, these claims require highly competent, educated, and experienced attention. It is importantly, decisions rendered in these complex claims often have tremendous effect on the lives of these veterans. Within VA's strategic plan refresh for fiscal year 2011 through fiscal year 2015, the Department of Veterans Affairs noted no fewer than 30 times that VA's strategic plan is results-driven, and I quote, "We will be measured by our accomplishments and not our promises." So today we want to hear accomplishments. What is going on in this high-stakes, highly specialized claims processing environment? How has employee training focused upon the development of these issues, and what is working and what is not working? Also, we want to hear about the focused investigations of the VA's Office of Inspector General, who look at specific complicated claims on an annual basis within the regional office. Reviews of VA OIG reports, as well as the recent veterans testimonials, are alarming. In the past 4 years, at least 19 regional offices have been inspected by the OIG on a second instance. Of those, more than half saw a decrease in the claims processing accuracy with respect to traumatic brain injuries. This means that the reports indicate that VA's OIG's second visit to the 10 regional offices evidenced more errors than the initial visit did. With respect to temporary 100% disabled claims, while improvements have been made on half of the offices are inspected, still could not process 50% of these claims correctly on their second inspection. There is still no other word for this but unacceptable. At this time, I would like to welcome our witnesses. We will have 3 panels here today. Currently seated are the participants of panel 1. They include Ms. Lauren Price, United States Navy retired, accompanied by Mr. James Price, who is also United States Navy retired, who are here on behalf of veteran warriors. To Mr. Price's left sits surviving spouse, Miss Betty McNutt, accompanied by Mr. Glenn Bergman, partner at Bergman Moore LLC. After the conclusion of panel one, we will hear from Mr. Sherman Gilmas, the Associate Director for the Veterans Benefits with Paralyzed Veterans of America, Mr. Ronald Abrams, Joint Executive Director for the National Veterans Legal Service Program, and Mr. Zach Hearn, Deputy Director for Claims with the American Legion. Finally, the third panel, we will hear from Mr. Tom Murphy, Director of Compensation Service with the Veterans Benefits Administration, accompanied by Ms. Edna McDonald, Director of the Nashville Regional Office. The third panel will also host Ms. Sandra McCauley, Deputy Assistant Inspector General for Audits and Evaluations with Office of the Inspector General, U.S. Department of Veterans Affairs, who will be accompanied by Mr. Brett Arant, Director of San Diego Benefits Inspections Division. Additionally, the hearing record will include written statements from disabled American veterans, the Tragedy Assistance Program for Survivors, and Ms. Sullen Schaefer, wife of Air Force veteran Eric Schaefer. With those instructions complete, I thank you all for being here today. I now yield to the ranking member for her opening statement.
Well, thank you, Mr. Chairman, and thank you for holding this important hearing. I also like to thank the witnesses you mentioned who are here today for their time and trouble to come and share information with us. First, I want to applaud the VA for reducing the benefits backlog by 34% since March of 2013. We hope that the VA can maintain this momentum, and we're optimistic. We want to end this decades-long backlog, and we're moving in that direction. Our numbers indeed show that the VA is on track to reach the Secretary's goal by 2015, so I would ask you to relay a message to the people who work for the VA and tell them thank you for their efforts and to please keep up the good work. As the VBA continues to work through this transformation, it's very important that we're working together towards solutions that will improve the processes of providing benefits to veterans, benefits that they've earned, and we want them to be provided in the most timely and efficient manner possible. So we need to be forward-looking so we can address the next issues rather than just the problems from the past. We want to be able to anticipate what's coming down the road so we don't create any new backlog issues. Earlier this year, our subcommittee worked on a package of bills that are forward-looking and I believe would help the VA provide better services to our veterans. The House has passed many of these measures. They were bipartisan measures, and I hope that the Senate will soon take them up and send them on to the President for his signature. One of the bills specifically was my bill Pay As You Rate, which I think is appropriate to today's topic as we look at complex cases that have more than one issue involved with them. This bill would require the VA to pay veterans as each of their individual medical conditions is completed. Such an approach would result in veterans throughout southern Nevada, in my district, and the country in receiving their payments in a more timely manner rather than waiting till the entire case is adjudicated, which can be very complex, as we'll hear. They can get pieces done as they go along. Additionally, it seems that such an approach would offer the VA better workload management options, where some of the best VA regional offices could specialize on those medical conditions which have proven to be more challenging and more complex, such as military sexual trauma and traumatic brain injury. My colleague, the ranking member Michaud, has introduced a bill that would provide veterans with better decisions in a timely manner by doing just that, and look forward to seeing that move forward. I'm proud to say that we seem to be making progress that's reducing the backlog, but there's still some clunkiness in the operations and in the effectiveness or lack of effectiveness. For example, I'm concerned that the VA may be oversimplifying some of the more complicated and complex medical conditions. The VA has essentially broken down the coding system with nearly 1,000 different medical conditions and endless variables into just 3 lanes, easy, medium, and hard. That seems a pretty simplified way of looking at all of these different variables. And when you define complexity as just the number of medical conditions in a claim, I'm not sure that's an adequate way of looking at it. It's important to note that the number of conditions doesn't necessarily dictate the complexity of the entire claim. This method of evaluating complexity made sense in a paper processing world, but as we look forward now to best practices, I believe complexity should be measured not just by the number of conditions, but rather by the complexity of evaluating and paying for the medical conditions that are under consideration. It's important that the VA look within the current system across all 56 VA regional offices to determine what are best practices for assigning that complicated work. I believe that the VBA can work with VBMS to broker work from one station to another to ensure that the best employees are working on the most challenging cases. This subcommittee, and I thank the chairman for his work on this and for his cooperativeness with our side of the aisle, and the VA share a common goal, and that's ensuring that our veterans receive the best benefits in a timely fashion. So I think we can continue to work together as a committee with the VA to develop these tools and best practices, and I look forward to hearing your testimony and seeing what options may be available to us as we move forward. With that, I yield back. Thank you, Mr. Chairman.
Thank you, Ms. Titus. And with that, I ask unanimous consent that Chairman Miller and Ranking Member Michaud be able to participate in our hearing today. So hearing no objection, so ordered. At this time, I would welcome our first panel to the table. Your complete and written statements will be entered in the hearing record. Mr. and Mrs. Price, thank you for your service and for being here this afternoon. Mrs. Price, you are now recognized for 5 minutes for your oral testimony.
Thank you, Chairman. Chairman Runyon, Ranking Member Titus, members of the panel. Veteran Warriors asked me to express their gratitude for inviting ourselves as delegates to represent their views on the VA's handling of complex claims and the challenges that are faced with those. Most of this panel has no idea who Veteran Warriors is. It's exactly what it sounds like. We are just a bunch of veterans. But we are specialists that come from a wide variety of fields and professions and bring, in some cases, decades of experience to the table and to the team. Our purpose is to deal with not just complex claims, but with all issues relating to the VA's functions. In particular, I am a combat vet. I served in the Navy for 7 years before I was medically retired. I contracted a terminal lung disease in Iraq. I also crushed both of my hands, parts of my hands, and had to have my hands rebuilt. I am 100% disabled. I can no longer work, and my life expectancy now is down probably less than 2 years. My husband is my primary caregiver. I don't need anything from the VA any longer. My complicated claim took 4 years to adjudicate. Not once in that 4 years did I ever present one single piece of new evidence. The entire claim was submitted fully developed in its entirety before I was even discharged from the Navy. I'm here not to represent my claim or my issues. My husband and I are here to make sure that this panel and that everyone that will listen to us will understand that cases like my own, and unfortunately like Mrs. McNutt, are not isolated. I personally have dealt with, at this time, almost 1,000 cases just in the last 6 months of veterans that are, and their spouses and children, who are dealing with complex claims that are being denied over and over and over again, or being lowballed and zero-rated. We are not a VSO. We are not a veteran service organization by any means. Our sole purpose is to work to try to get resolution to the manner in which the VA is conducting business. However, we're not going to sit here and lie to anybody. We are going to make sure that everyone understands that we do not agree with giving kudos to the VA. Over the last 12 years, the majority of the veterans that have come home and come into the system have filed complex claims. This wasn't a secret to the VA. They were well aware of what was coming home. You have a demographic of veterans that have spent multiple deployments, various hostile environments, come home, are better educated now than they ever have been in history. They're also equipped with technology available that at a moment's notice they can get information to virtually any question they have regarding their benefits. The VA pictures this as a disaster waiting to happen because these are the veterans that are filing the complex claims. On November 7th, Secretary Shinseki took credit for reducing the backlog by 1/3 since March. We caution this panel and everyone involved with VA claims to don't take that as gospel, because there's a big part of claims processing that they're not telling people. The most insignificant type of claim is not a medical claim. It's called a dependent status change. You get married, you have a child, you get divorced, your child ages out. It's a one document with one attachment, your marriage certificate, your divorce decree, what have you. Those go into claims. They are adjudicated right alongside someone who has a terminal lung disease or Agent Orange illnesses. Unfortunately, those claims, and we have been able to prove it to this subcommittee, those are the claims that they're closing and calling closed and adjudicated. And unfortunately, that does help their numbers come down. We ask that every time that you get a new report on the VA's numbers, you look at it cautiously, you question the data. They're not sending in screenshots of their work product. They're creating reports. There's almost no transparency. No one in this room can just sit down and go look at all the numbers that the VA is working on that are being generated on a daily basis. Congress has never denied the VA a single penny for doing its job. The current budget, over $54 billion, is being paid out to veterans in direct benefits. The balance of their budget that they receive right now is for administration of their business. But they're not doing business properly. I could sit here for hours and give you statement after statement after statement of egregious behavior, wrongful denials, or in some cases, deliberate malfeasance. All we ask is that you continue to press this forward. You consider our mission, which is to have a full overhaul of the Veterans Administration, completely reorganizing the way they're doing business and demanding full and 100% accountability and repercussions for their actions. Thank you again, Mr. Chairman, Ranking Member Titus, esteemed panel. We're extremely grateful for the opportunity to be here today to testify. We'll be honored to take any questions from you.
Thank you, Ms. Price. And now we will hear from Ms. McNutt. Please begin your statement when you're ready.
Thank you, Mr. Chair.
You have the
About the
microphone on.
complex VA claims. My name is Betty McNutt. I'm the widow of Ronald Adrian McNutt, Vietnam War veteran. Accompanying me today is my attorney, Mr. Bergman of Bergman and Moore. The Subcommittee on Disability and Memorial Affairs invited me here today to discuss what has become my most complex and now 23-year-old claim. For VA dependency indemnity compensation, I'm here for two reasons. First, I'm here seeking justice for myself and for my family. I ask VA to correctly and promptly apply the law and grant my claim. Second, I'm seeking justice for other widows and orphans of our Vietnam War veterans. In the audience today is my son, who lost his father and his best friend when he was 12. Also in attendance today is my niece, Sandra Peterson, who's the daughter of a Vietnam War veteran who also died from Agent Orange poisoning. Mr. Chairman, I filed my claim in 1990. This same claim remains pending. I waited 8,600 days of VA delays and denials. VA erroneously denied my claim 7 times. For nearly 12 years, my claim sat idle at VA because VA did not respond to my notice of disagreement. The Court of Appeals for Veterans Claims returned my claim to VA 3 times based on errors conceded by the VA. I know that VA is waiting for me to die. Without immediate attention, my claim is destined to sit idle for several more years as I wait, hope, and pray for a resolution. My late husband, Ronnie, was born in Memphis, Tennessee on December the 31st, 1947. As a 19-year-old college student, he was drafted into the U.S. Army. Ronnie was deployed to the Vietnam War in 1968 and 69. On September the 22nd, 1987, at the early age of 39, he died from an aggressive form of cancer, leaving me a widow with a young son. His death came quickly from a cancer that invaded many parts of his body very rapidly. Ronnie died within 5 months. I brought a picture today of my Ronnie because this hearing today is honestly about my Ronnie. He died because of the Vietnam War and his service to his country. On his deathbed, he told me about how he swam in rivers highly contaminated with Agent Orange. Ronnie told me stories about using discarded Agent Orange barrels for barbecue pits. First, VA has not contested that my husband served on the ground in Vietnam. Second, the law presumes veterans on the ground in Vietnam were exposed to Agent Orange. And third, a medical expert provided the VA with 2 nexus medical opinions concluding that Ronnie's cancer was as likely as not due to his exposure to Agent Orange in Vietnam. VA's Jackson, Mississippi regional office made many mistakes. First, on more than one occasion, the VA applied the wrong legal standards to decide my claim. Second, VA ignored favorable medical evidence to my claim. And third, the VA sought evidence to deny my claim. A lot was taken away from me 26 years ago, and I've done the best that I knew how as a widow to provide for my son, Brandon. The impact of my husband's death on my son was tremendous. Words can't tell you. I have had emotional, physical, and financial distress. For me, I have suffered unimaginable grief from Ronnie's death. For 8,600 days, words cannot express my suffering. Going with my VA benefits has meant going without them has meant coming home, different occasions, to a very cold and dark house because my utilities were turned off. It's meant receiving food and clothing from strangers, as I sometimes came up short. It's meant begging for mercy, as a repo man stands in my driveway at 2 o'clock in the morning to take my car. In conclusion, the VA's mistakes and their delays involve more than just me. It's not about just Betty McNutt. There's many Betty McNutts out there. Congress passed a law mandating that VA expeditiously process appeals like mine. However, VA routinely ignores this law. Now's the time for Congress to put teeth into that law, so other widows like myself can get accurate and prompt decisions on their VA claims. Mr. Chairman, no one should have to go through that for 8,600 days. Thank you for listening to me.
Thank you for your testimony, and both Ms. McNutt and Ms. Price, thank you for being here and putting a personal view to all of us. Start with a round of questions. I know the clocks aren't up, but we'll be able to see it from this end. So to get moving in a timely manner. First question is for Ms. McNutt. Talking about this process and moving forward with you're accompanied by your attorney, Mr. Bergman here. Could you tell us about when you decided to engage in counsel and how that has helped you to get to where we are today in this process? Because like you just kind of alluded to, there's many other people out there in the same situation.
As I said, I was introduced to Agent Orange on his deathbed. And after his death, that was forever in front of my mind. So I proceeded without any help, without any direction. I started researching the chemicals in Vietnam. I read an article in a newspaper, and it was talking about Agent Orange, and I filed a claim in 1990. Most of these were just, as I said, stumbling in the dark, grasping. But as I went along, the more I learned, and the more I felt it was something that I had to do, because my husband told me about this on his deathbed for a reason, which at the time I did not understand.
Can you give a little insight, though, on how counsel...
After 20 years of groping in the darkness and dealing with the VA and all their eras, I prayed. I asked for help. And one day I received a call from the Vietnam Veterans of America, and I was told that I might want to seek counsel. I went online and I found Mr. Bergman, and I decided this is going to be the person that's going to help me. This is who I want to represent me.
Mr. Bergman, can you elaborate on a little what you've done to expedite the process, if you will?
Certainly, thank you. As Mrs. McNutt has indicated, she commenced her claim in 1990, and her claim sat for over 12 years. When we came on her case, as former VA counsel, my job, once I left VA's employ, our job as attorneys is always to connect the dots, make sure that the evidence that is needed to satisfy the requirements is presented to VA. VA is supposed to, in its non-adversarial posture, paternalistic posture, is supposed to give notice to veterans and widows They routinely do not do that. So what we did in Ms. McNutt's case is we assisted in getting the medical evidence, and it wasn't difficult. Her husband had a very aggressive form of cancer at the age of 39, and we put the evidence together with our arguments and submitted it to VA. And, we can do all we can to dot our I's, cross our T's, but we cannot make VA properly apply the law. And we've been up to the U.S. Court of Appeals for Veterans Claims 3 times. And each time a VA attorney will trot forward and say, we made a mistake, this case needs to go back. That doesn't help Mrs. McNutt, but we're hopeful that it's been 23 years. We're hopeful we're near the end. Some of the help that we got along the way, obviously the Veterans Choice Act of 2006 has been helpful in allowing attorneys early access to assisting veterans and widows.
Thank you. And one question for Ms. Price. From all the testimonials you've taken from veterans on a national scale, what are the most frequent errors you've heard of in the process?
Really in any ranking order, Chairman, but most specifically, as Counsel Mr. Bergman said, failure to apply the law correctly, complete disregard of medical evidence provided, most specifically from civilian providers. That is very high on the list. And the third one, and this rides to the top pretty regularly, is the almost complete and utter disregard for anything that is considered a policy, rule, regulation, or law. The raters seem completely incapable of rudimentary reading of their own forms of a policy. I have a very specific one in my case. The secretary sent down a policy change and order directly to the regional offices with regard to those of us exposed to burn pits in Iraq and Afghanistan, April 26th of 2010. That application of that law, that policy change has, to the best of my knowledge, not been addressed once in the almost 5,000 victims I know personally.
Thank you. And with that, yield to the ranking member for her questions.
Thank you. And thank you both for your testimony. You're very courageous to come, and we appreciate your willingness to share your stories. We don't want to see anybody else have to go through what you have. I understand the general dissatisfaction and the desire to make the VA follow the law and to overhaul the way they do business. But can you tell us just start with one specific thing, and I would ask both Ms. McNutt and Ms. Price, one thing that we could do through legislation that would make the process work better, because that's what we have to work with. How can we change the law, or how can we change the policy in a specific way that would improve circumstances? Ms. Price?
Yes, ma'am. I have a very specific answer for you.
Okay.
You could create a law that essentially orders the Secretary to establish a complete set of repercussions and an oversight agency that has the ability and the authority to dish out those repercussions. That when malfeasance, deliberate especially, is shown on the part of a rating official, on the part of a case manager, on the part of a healthcare provider, that those people can be terminated, that those people can suffer the repercussions like any civilian would for doing their job poorly or deliberately not doing their job the way it's supposed to be done.
And I would ask the attorney, if somebody is guilty of malfeasance and they're doing their job, aren't there already in place some ways to go after that person? You were a VA attorney, is that correct? I'm talking about in response to what Ms. Price just said.
I don't deal much with malfeasance issues. What I deal with, Ranking Member Titus, is appeals where each case that comes down from the court has language citing to the law, Title 38, Section 7112, that says this case will be given expeditious treatment. Now, and I realize I'm not being responsive to your
That's
question.
right, never mind. I can ask the VA for some of that information. I appreciate that suggestion. Ms. Minette?
There's got to be someone somewhere that has the total authority in making sure that the training, they say there's lack of training, lack of technology. I don't understand that. If I acted in those ways, I would have been fired, but I think stronger force should be put on them to enforce the law by putting someone in place, or maybe more than one person, that would oversee that this law is enforced, that it is a serious matter, and that something's got to change. And I'm with her. If you can't perform your job, find another job.
Mm-hmm. Thank you, Mr. Chairman.
Thank you, gentlelady. With that, I recognize Mr. Lamborn.
Thank you, Mr. Chairman, and thank you for having this hearing, and thank you all for being here. And I want to build on what the ranking member just asked. Mr. Bergman, you've been on both sides now legally, and you're with your employment previously and what you do now. Do you have any advice or guidance you would give this committee on how the VA could work its claims process better?
I guess the advice I would give, sir, is that there be accountability. What I see is a lack of accountability at the agency level, where we are not supposed to be on opposite sides of the aisle. VA will not talk to us. If we do get someone on the telephone, they'll ask us how we got their number. We get differing responses each time. We cannot handle many cases at the agency level sometimes because we don't know where our file is, because we get differing responses to that. So I think if we can hold the folks who are deciding these claims accountable, that would help veterans and widows and their counsel in expediting the process.
Accountability, that's a great thing to bring to our attention. Training and incentives for, do you have any advice in those areas?
As Mrs. Price talked about, she indicated her concern that it seemed like that some VA raters do not follow simple guidelines. Absolutely. Training is key. I think the VA's OIG report of last year indicated that, and I may be misquoting, and I think the OIG is going to provide a report later today, but only 20% of the raters are properly trained. That means 80% are undertrained. These are people who are deciding our veterans' disability claims. Not acceptable, I would say.
Okay, thank you. Mrs. Price, I want to thank you for your service, and Ms. McNutt, I want to thank you for your husband's service. Mr. Chairman, I yield back.
Thank the gentleman. With that, I recognize Mr. O'Rourke.
Thank you, Mr. Chair. And I'd also like to thank the chairman for organizing today's hearing and in the manner in which he's organized it. Very often we'll hear from representatives from the VA, and then afterwards perhaps hear from VSOs or others who are impacted. I like this order because I'm really looking forward to hearing the VA's response to the issues that you brought up. And the word that we keep hearing over and over again is accountability. And to use your word, Ms. Price, repercussions. We want to see how that accountability is implemented and what the consequences are when someone doesn't do their job properly, or when there's the case of malfeasance or someone who is working against the interests of the veterans that they're supposed to serve. We want to know what the consequences are specifically, and I think you've raised a great point, one that hit home with me, and it sounds like with the rest of the committee. And Ms. McNutt, as I said earlier when I had a chance to meet you before the hearing began, I commend you on your courage in being here. I hope that your story helps galvanize the VA, one, to resolve your claim, which has taken far too long already, but also to serve as the added inducement to ensure that no one else is suffering what you have been through, and to bring stories like yours to our attention as an oversight committee and body and to the attention of the VA. So really appreciate your service, Ms. Price, and through you, Ms. McNutt, your husband's service and your support of him and his legacy and memory, and both of you, your efforts on behalf of other veterans and veterans' families who are suffering these same kinds of problems. So I really don't have any questions. I'll reserve those questions for the VA based on the issues that you brought up, but I just want to let you know that your stories have hit home, and I really do think they're going to have their intended effect of changing the culture and adding additional power to our ability to exercise oversight over the VA. So thank you, Mr. Chair. I yield back.
Thank you, gentlemen, and Chair now recognize Mr. Bilirakis.
Thank you, Mr. Chairman, and I appreciate you holding this hearing, a very important hearing. And I appreciate the testimony of Mrs. Price, who I know pretty well. We worked together over the years on VA issues, and Mrs. McNutt, thank you for your courage. And I know you will make a difference for others. And I really appreciate so very much for both of you testifying today. Mrs. Price, first of all, thank you for your service as well. Thank you for testifying, and I want to ask you a couple questions, if that's okay. You've met with me over the years on particular casework, and I really appreciate it. And you worked with my district office as well to help our true American heroes, our veterans. I have a question with regard to, again, can you elaborate a little bit on your particular case, what the experiences that you've had over the years? I think that would be helpful to the committee as well, if you will.
Thank you, Congressman. It's actually been my honor and privilege to work with you over the last few years, in particular for other veterans issues. I know you're extremely supportive of all of us that have come home, whether we need VA services or not. But to answer your question, when I got home, I was still on active duty. I was stationed at CENTCOM, and I was sick, and I was injured. And I went through the medical board process. And it took, by the time it was completely finished, it took about 10, 11 months for me to get through my board process. But I stayed on active duty for 18 months total, and my first rating from the VA came in, and it said, you have 30%. There's a rule in place called the DeLuca criteria that has been around for decades based on a court case. It has to do with every single one of us that has bilateral appendage injuries, arms, legs, ears, eyes, anything you got two of. Up until the time I had a DRO hearing, I had, it appeared to be the same case manager because I'm an English aficionado, and the method in which the way the person wrote letters to me, the verbiage the person used, seemed to be the exact same person every time. The raw rating on my hands is 230%. And that's a big number, but they have a very algebraic method of using cumulative math. Both of my hands, I had the bones removed and my tendons rerouted so that I could actually even hold this. I can't tie my shoes, I can't button buttons, I can't do Ziploc bags, all kinds of things. My last surgery was while I was still on active duty. I also contracted this lung disease. When I sent all of this information and including some very elaborate ratings on my hands, a testing that took 5 hours, The first letter that came back to me was telling me that the amputation rule didn't apply to me, which is a very basic rule that the VA has when you hit a certain calculation level, that we just say, okay, we're done. You know, we're too high up. Now you just go over and use the amputation rule, and you treat it as loss of use or loss of the limb. Said you didn't lose your hands. What makes you think you get to use the amputation rule? I had essentially that same answer all 3 appeals. My lungs, they told me I didn't, both my lungs and my hands, they told me I didn't qualify for combat-related or SMC. I was a convoy driver. I have over 350 missions. I drove Humvees. I drove LMTVs. I even drove an Iraqi city bus in downtown Baghdad. And I provided all of that information in my case. Pictures taken by combat cameras of me driving. They still denied me over and over and over again. I have PTSD for a variety of reasons, up to and including being a combat driver. When I filed the claim, they denied me right away, immediately. They said, you don't have it. Our evaluator said that you must have had a bad childhood. No, actually, I didn't. My childhood wasn't terrible. It wasn't great. I was a kid. But it had to do with the issues that happened over there. And I was being treated by their own psychiatrist and their own psychologist for a year who said I had PTSD. But yet they still denied me. Does that answer your questions, Congressman?
Yes, yes.
Thank you very much.
Thank you very much. And I know my time has expired. Well, we have another round. I know you have 3. Can I have one more question? Thank you very much. Mr. Price, the VA stated in its testimony that from 2009 to 2013, the average number of issues included in a disability claim increased from 2.8 to 4.9, and that the VA is issuing lanes as an organizational structure to process complex claims. They stated that the core lane includes claims with 3 or more medical issues that do not involve special populations of veterans. That's a quote there. Can you expand upon your thoughts about this aspect of the VA's testimony?
With specific to core claims,
With specific to the process.
Okay.
With regard to, yes.
putting things into lanes.
The lanes, correct.
Okay.
Correct.
Does anybody here drive in traffic? Does anyone here ever drive on the Beltway? You have lanes. There's only so many. And there are express lanes. And in theory, everybody uses the express lanes. How many people have seen the news stories about the guy riding with the mannequin in the seat to get into the express lane? Yeah, there are going to be good ones that go into those express lanes. But our special operations claims, I love that they took that title. We are complicated claims. Those complicated claims are still being ignored and still being pushed aside because the lane that they have has a group of adjusters and raters that are dealing with them. Instead of them being either brokered out to other regional offices that don't have a backlog, like Nebraska, Oklahoma, they're not brokering them out, they sit on them. And then they have these core, which I don't even get what core is. Okay, so you have 3, they call them the express lane for 1 or 2. If you hit 3, but it doesn't hit into what seems to be a rather fluid definition of special or complex, you end up in the core. They're also not giving any information as to what the qualifications are of these people that are managing those lanes or those raters that are working in those lanes, because experienced rater does not tell me anything. How many years did they have rating medical claims for MetLife before they went to the VA?
Thank you. I'll go ahead and you're back. Thank you, Mr.
Thank you, gentlemen. Chair recognizes Ms. Naget McLeod. No questions? Chairman Miller? Nothing? I want to thank you all again for your testimony and being here today. You are now excused, and we'll ask the second panel to come forward to the witness table. At this time, I'll welcome panel 2, which includes Mr. Sherman Gillums, the Associate Executive Director for Veterans Benefits with Paralyzed Veterans of America, Mr. Ronald Abrams, Joint Executive Director of the National Veterans Legal Service Program, and Mr. Zach Hearn, Deputy Director for Claims with the American Legion. We appreciate all your attendance today. Your complete and written statement will be entered into the hearing record. Mr. Gillums, you are now recognized for 5 minutes for your testimony.
Thank you, Mr. Chairman. Chairman Runyon, Ranking Member Titus, members of the subcommittee, on behalf of Paralyzed Veterans of America, I want to thank you for this opportunity to discuss complex claims, a topic that is near and dear to veterans like me and those who represent at PVA. Complex claims by their nature involve those cases that require the most experienced eyes and minds to properly adjudicate. These can be the oldest claims in the inventory, claims with multiple issues, or those presenting the most complicated circumstances to unravel, such as military sexual trauma, PTS, and catastrophic disability. Since membership in PVA is predicated on catastrophic disability, that will be my focus. PVA service officers have honed a unique expertise in developing and advancing the most complex claims in the system, where special monthly compensation, or SMC claims, are often the exception. For most accredited representatives, they are fairly common for PVA, so we appreciate this long overdue focus on complex claims. The Veterans Benefits Administration has made tremendous strides in reducing the backlog since launching the 21st Century Transformation Initiatives. But as we said during our June 2012 testimony, complex claims remain problematic because disability benefits questionnaires, evaluation builders, and rules-based calculators too often oversimplify cases that require critical thinking and inductive reasoning, not algorithms, to adjudicate with true accuracy. So any accuracy numbers achieved through the use of these processes are qualified by context as it relates to complex claims. The problem is defining accuracy in these cases often lies in the eye of the beholder. If by accuracy, VA means the veteran receives maximum entitlement, then accuracy targets remain unmet. VA contextualizes accuracy to mean if the rater inputs a given data set, such as the boxes checked on a DBQ or C&P exam results, and follows the rules-based prompts, the decision will be free of error based on its algorithmic construction. The problem is disability evaluation builders do not encourage the application of judgment-based principles like reasonable doubt, or guide rating specialists through ambiguities in the evidence, like reconciling the difference between total loss of bladder control versus neurogenic bladder sphincter in someone with a spinal cord dysfunction. And this is where we have issues with the way complex claims are adjudicated under a rules-based system. A veteran with severe disability may receive an accurate SMC rating under VA's definition based on limited evidence and binary rules, but not the most accurate rating possible that reflects the true extent of disability or need. I'll give you a case in point that deals with the terrible condition that PVA sees all too often, ALS or Lou Gehrig's disease, a fatal motor neuron disease that does not slow down for the painstaking protocols that VA must follow. Since the passage of the presumptive rule on ALS open entitlement to veterans and survivors, PVA has worked over 6,200 ALS claims, which has made our field staff well familiar with these complex cases and extremely staunch and are insistent that they are timely and accurately adjudicated. So you can imagine my reaction when I heard about a veteran in San Diego who received notice that he needed to submit to a compensation and pension exam to prove his need for skilled care despite presenting competent medical evidence of such need from his treating physician. VA has a prerogative to call claimants in for exams pursuant to a claim, but this prerogative has become one of those intractable rules that we criticize. The problem is this veteran was in hospice, so he could not submit to an exam. The VA rater, an experienced lane coach, was bound by the quality-driven rule that C&P exams are mandatory, even though he had enough evidence to grant this R2 claim and the regulatory discretion to do so under Title 38, which states any hospital or exam report from a government or private entity may be accepted for rating a claim without further examination. The VHA directive on acceptable clinical evidence also allows VA examiners to supplement the review of claims files with a telephone interview if necessary with the claimant in order to complete a DBQ. But neither option was exercised here. The words hospice and skilled care noted in the medical records simply triggered the requirement to order a C&P exam in the name of quality. Instead of serving as prima facie evidence of imminent death, thus substantiating the need for regular skilled care. Common sense will give way to a calculator, which is supposed to be a decision support tool, not replacement for one's reasoning faculties. To make this point, I offer an analogy. 3 plus 2 always equals 5, and if every disability claim were based on metrics like decibel level or percentage of range of motion, a high degree of accuracy would be achievable under the current system. But these complex claims are like adding two irrational numbers, pi, 3.14, so on and so forth, plus the square root of 2, to arrive at an outcome that cannot be precisely summed with a calculator. In that same vein, these claims call for an informed, qualitative analysis to find the most accurate, albeit imprecise answer. That answer was never found in the San Diego case, as the claim ultimately died when the veteran finally succumbed to his ALS. This was a missed opportunity to do the right thing. Unfortunately, this is not an isolated case. We see VA regional office staff across the country pointing to the same rules to justify taking unnecessary steps in similar cases. And I can point to one in Nashville for Ms. McDonald, who's going to follow this panel. She's the regional office director who will testify. And, of course, in New Jersey, Mr. Chairman, I also have a case for you if you're interested. We understand the dilemma VA faces under pressure to reduce the backlog while achieving timeliness and accuracy targets. But every aspect of this problem is not a numbers game. In the case of complex claims as we define them, there are no shortcuts to doing them right. They require experienced minds that are free to apply common sense and pro-veteran legal principles like reasonable doubt or foregoing CMP exams when existing evidence is satisfactory in a qualitative deliberation of claims with no black and white answers. As I said earlier, accuracy is not about how well VA raters adhere to a set of protocols to arrive at an ostensibly logical outcome, notwithstanding obvious blind spots in the process. Accuracy is measured by whether VA has provided the maximum benefit possible in these complex claims with imprecise answers that do not lend themselves well to binary propositions and calculators. Thank you, Mr. Chairman, Ranking Member Titus, and members of the committee, and I'll be happy to answer any questions you have.
Thank you, Mr. Gomes. With that, I'll recognize Mr. Abrams for 5 minutes.
Thank you. I've been involved in veterans law for over 40 years. The VA has faced huge backlogs before, and the VA has had to deal with reducing the backlog, adjudicating claims faster, and in almost every instance, the error rate, especially the error rate for complex claims, has gone up. You just simply can't go too fast when you have complicated claims. The first thing we have to talk about is what is a complex claim. Some claims by their very nature are complicated. Special monthly compensation, traumatic brain injury. In fact, the regulation dealing with TBI is so complicated that some people call it the Da Vinci Code. Try and look at it sometime and you'll be impressed. Some claims can be complex as they are developed by the VA or as evidence from the claimant comes in. Ancillary issues arise, different theories of service connection come up, they can become very difficult. And some claims, more than a few and more than I like, can become complicated because of VA error. And in those cases, the veterans face a nightmare. Not only do they have to get the right evidence before the VA, they have to overcome the unfair denial, which is an obstacle that stands in their path. The worst type of VA errors are the result of premature adjudications. Some VA ROs incorrectly adjudicate and prematurely deny claims based on inadequate evidence, especially inadequate VA exams. These errors reveal for many veterans that the claims process can be adversarial. Based on my experience working for the VA for many years, working for NVLSP, going on quality checks to over 40 VA regional offices for the American Legion, who should be commended for doing that work, shows to me that the error rate at the VA has been consistently at least 30% in the various ROs. Sometimes it's higher. It's unrealistic to assume that the VA will ever get its real error rate to 98%. Over 70% of the claims appealed to the Board of Veterans' Appeals are reversed or remanded. And over 70% of the claims taken to the court are sent back because of VA error. In fact, NVLSP wins over 90% of the claims that it takes to the court. In its rush to judgment, we have found that many ROs, VA ROs, prematurely deny or ignore many claims and potential claims. Unfair, premature denials cause unnecessary appeals and years of delay before deserving veterans obtain justly earned benefits. And even more important, some veterans fall through the cracks. Adjudicating many claims quickly doesn't do much good if many of these adjudications are done in a premature manner and many deserving veterans are unfairly denied. What will happen is veterans will appeal, the backlog will eventually grow, and we'll be facing this over again. I wish to commend the Undersecretary, General Hickey, for her commitment to the fully developed claim program. I think it's the best thing that the VA has tried in over 40 years, and I encourage it. We suggest the following. The VA work measurement system, which encourages people to prematurely adjudicate claims, has to be overhauled, even if Congress has to pass a law. The VA needs more people to work these claims. In spite of electronic this and lanes and all the other things the VA is trying to do, which is a good thing, they don't have enough people. They need more people to work the claims. And finally, the adjudication culture at the VA needs to be changed. Many VA managers that we've met on our travels unfortunately act like they are producing widgets rather than adjudicating claims filed by real people. You saw the real people here today. Their goal should not be prompt adjudication. The goal should be a timely, accurate, and fair adjudication, which in the long run, not in the short run, is the best way to finally adjudicate claims and reduce the backlog. Thank you.
Thank you, gentlemen. And with that, I know we have pending votes on the floor, but we may get to questions after Mr. Hearn does this. If not, we'll go into recess and we'll come back afterwards. So, Mr. Hearn, you are now recognized for your testimony.
Good afternoon, Mr. Chairman, Ranking Member Titus, and members of the committee. We're here to talk about the implementation of special operations lanes. VA created these to address accuracy. What we never talk about, though, is why accuracy matters. VA estimates they will process over 1 million claims again this year. The difference between their goal of 98% accuracy and even 97% is over 10,000 veterans who may not get the benefits they earned. We all know the real gap in accuracy is far more than 1% as well. We're talking every year a small city in America full of veterans who may not get the benefits they earned through their hard years of service. Each of those veterans is a story and a family too, unique in its own way, like the stories we just heard from the first panel. That is why the American Legion is constantly raising the importance of accuracy. Because for all those veterans who wind up on the wrong end of those errors, VA's accuracy rate may as well be zero. Why are there still problems? It is a complicated system. It does take experience and attention to detail to get things right. Putting experienced personnel on the tougher claims is a good start. When VA has the ability to ensure this is consistently applied across the country with the right personnel to execute this plan, it will probably help with improving the figures. But there are still some systemic problems which hamper VA's ability to get it right for veterans. I have been fortunate to travel to many VA offices as part of the American Legion's Regional Office Action Review Program. For over 15 years, we've been conducting these week-long intensive visits to VA offices to review claims and assess VA accuracy, and to see inside the offices outside the Beltway and get a true picture of how the implementation works in the field. Through these visits, we've seen patterns. For example, consistency from one office to office leaves much to be desired. Policies embraced by leadership in one office may be given lower priority in other offices. And with mixed commitment, you get mixed results. VA also seems to struggle with finding the right balance of development for claims, which leads to adjudication errors. You can't build a house on a shaky foundation. On our review visits, we examined a sample of dozens of recently adjudicated claims for veterans the American Legion represents. Often the claim has either been underdeveloped or overcomplicated. Both of these early errors are a recipe for bigger errors later in the process. VA has a tendency to underdevelop claims and leave adjudicators with too little information to make a fair judgment on service connection or rating. For example, in April 2013, we visited the Nashville Regional Office. According to the April 27th Monday morning workload report, Nashville had a 95% accuracy rating for the previous 3 months. During the review of 22 cases, we found 11 where we commented regarding case development to include 7 with errors. Our review paints a far dimmer picture of Nashville's accuracy than indicated in the workload report. In one case, a veteran was seeking service connection for PTSD. Evidence within the file obtained from a vet center indicated the veteran served in the Persian Gulf during Desert Storm and was chronically fearful of death due to chemical warfare. Additionally, the vet center exam noted treatment for symptoms associated with PTSD in service, and at the time of the vet center exam had extensive symptoms associated with PTSD. No exam was provided by VA. A rating decision denied the veteran's service connection for the condition due to a lack of diagnosis. Yet, if a veteran exhibits symptoms of a condition, a VA compensation and pension exam should be afforded. The veteran exhibited symptoms that should have triggered an exam. An exam was never scheduled, and instead, VA opted to simply deny the veteran benefits without due process. Conversely, sometimes VA doesn't seem to know when to stop and overcomplicates a claim. In June, we visited the Reno RO. The June 3rd workload reports indicate they had a 93.2% accuracy rating. Our review of cases resulted in comments regarding the adjudication of 59% of reviewed claims for VA benefits. In one instance, a veteran was seeking service connection for PTSD. During a July 2011 VA C&P exam, the examiner linked the veteran's condition to military service. The regional office returned the exam results in August 2011 to the examiner to again restate his opinion. And again, the examiner stated the veteran's PTSD is related to service. After the second review, VA finally adjudicated the benefit in September 2012 and sent the notice letter in January 2013. VA conducted 2 exams when only 1 was necessary, and it took over 2 years from the date of the first exam to adjudicate the claim, and then another 4 months to notify this veteran. The American Legion believes these problems could be mitigated by adopting some strategies our National Commander Dan Dellinger advocated for during his testimony before Congress this fall. Fixing a work credit system that currently places more emphasis on actions completed than actions done right. Aggregating common errors to develop a training plan. These are steps we want to see taken. Fixing the accuracy problem needs to start with the right mindset. The mindset should not be achieving 98% accuracy. The mindset needs to be, I need to get every step right for this veteran. Until the problem gets fixed, we're losing the good faith of a city of veterans every year. Thank you, and I'll be happy to take questions.
Thank you, Mr. Hearn. And seeing that there's probably less than 5 minutes left on the clock on the floor, we're going to have to go into recess, be back half an hour to 40 minutes. So as of now, the committee stands in recess.
Yeah, because they're going to take questions.
Can we have some cookies and milk and cookies or something?
Subcommittee will come to order, and we will begin a round of questioning, and I will start that off. And my first question will be for Mr. Abrams. You note in your written testimony that one manner in which claims become complex is because of VA error. Cases of this sort are often appealed and then remanded, and often more than once, further increasing the complexity of the claim procedurally. Number one, can you elaborate on the common types of errors you see which causes claims to become more complex due to VA error on appeal? And number two, do you think that greater focus on appealed and remanded claims would assist VA in learning from its mistakes and making less of these types of errors in the future?
Yes, I can. Let me give you an example. Suppose a veteran files a claim for PTSD. The veteran alleges that he suffered a stressor when exposed to combat. The veteran's service records show a combat infantry badge, which means the veteran was in combat. However, the VA, in an effort to go fast, sets up an examination and fails to tell the medical examiner to accept as true the fact that the veteran was exposed to combat. The VA examiner looks at the file, doesn't see any evidence of a stressful incident in service, doesn't know how to read a DD-214, and determines that he could not diagnose PTSD without a stressor. Therefore, he writes a negative medical opinion and diagnoses the veteran with anxiety disorder or something like that. The VA then denies the claim. To resolve that claim could take 5 to 8 years. And the VA needs to take the time at the start. This is just a simple error. I could get into complicated ones, and we'd be here much too late. But that's a simple error that can be fixed if the VA takes the time at the start to tell the doctor what evidence to accept as true. That is not for the doctor to determine. It's for the adjudicator, the VA adjudicator, to make that finding. Your second question was if they got more involved. I'm not sure what you mean by more involved with remands.
If they pay closer attention to the process.
Well, they should. They need to analyze the types of remands that come back from the board and take action to train on that. We certainly look at thousands of cases a year, and we keep a list of the common errors that the VA makes that we can win at the court for. And in my testimony, we listed some of those that you can see. But I'm hoping that the VA does that. I'm not sure that they do.
Thank you. And again, for Mr. Abrams and Mr. Gillums, maybe you both provided examples in your written testimony of issues with VA adjudicators properly calculating the amount of special monthly compensation for severely disabled veterans. Why do you think that calculating SMC is so problematic for VA adjudicators?
Do you want me to answer that
Please.
first?
Yes, please.
Okay. First of all, in my experience, and I think you have staff members who have traveled to ROs that have seen this too, SMC is inherently a complicated issue. Second, there are some things that the VA looks for magic words for that aren't there. In the case I wrote about in my testimony, the veteran's military doctor said he had lost all function in his right hand, and he had lost the use of his right foot. The VA did not concede loss of use of the right hand because the doctor didn't say the magic words. When we contacted the doctor changed his written comments and said he had lost the use of the right hand. Well, loss of use of a right hand and loss of use of a foot generates an L, SMC-L. He already had an L because he was in need of A&A because of his traumatic brain injury. This is a man who was shot in the head in Iraq, had 18 service-connected conditions, operates on a grade school level, has tubes in his head that fluid comes out of, has terrible scars on his face, lost the sense of taste and smell, and has suffered tragic wounds. I got involved because I wanted to help this guy. My heart went out to him. And even after we produced clear evidence that he should get SMCR2, slam dunk, the VA didn't act. So I finally was able to reach the component of the VA that does that work. And I asked them why action had not been taken. And they told me they were looking for loss of bowel and bladder control. And I said, that is irrelevant. You don't need it. He already qualifies. And the lady was able to hear me out, and I took her through the regulations and statutes, which would take me a long time to go through. I wrote it up. And the veteran ended up getting the R2. It's on our website if you want to go look at the whole thing. We had a mix of the VA, like the band in Animal House that marched into the wall. It didn't have loss of use, it only had loss of function. They weren't going to accept those words. Kind of silly. But secondly, the people that were doing the work didn't know the law. The VA needs to do more to train people to understand SMC. The PVA, the DAV, the Legion, MOPH does a lot of work on that issue. And if you look in our textbook, we have a formula that service officers and VA can use to properly evaluate. It's complicated, and you have to look at it each time.
Thank you.
Thank you.
Mr. Gomes?
In order to effectively adjudicate an SMC claim, you almost have to have an intuition for things that are pretty abstract, like how do you measure need? In one case, you'll have a veteran with ALS, because he or she has trace function in her legs or can barely stand, the rater will find that the veteran has useful function in her legs. And we argue it has to be useful in terms of daily living. And so a lot of it is, over time, it'll be cultural. This culture, this new crop of raters are being trained to follow rules. I'll give you an example. If a veteran presents with a letter from his clinician saying that he needs skilled care, that letter will trigger not some deliberation on the rater's part, it triggers the need for a CMP exam. The CMP examiner will render an opinion as to whether the skilled care is needed or not, and depending on what that CMP examiner says, will dictate whether the claim is accepted or denied. The problem is, in the past, if you were a trained rater and you understood SMC, you knew how to weigh evidence, you knew how to weigh two conflicting medical opinions, and in that case, it should be resolved in favor of the veteran. Well, increasingly, this contemplative aspect of rating SMC is being pushed out of the culture, being pushed out of the process, and so there's no contemplation of evidence. It's either there or it's not. This person can either walk because they've got 3 out of 5 function, or they can't, with no exploration into whether it's useful or whether the 3 out of 5 results in multiple falls because the veteran tries to stand but can't and incurs subsequent injury. So a lot of it has to do with the fact that I believe the VA is going away from this inductive reasoning way of training its new people that probably made claims adjudication a bit longer, but it was more accurate if you got it right the first time. And so that's my insight.
Thank you. And recognize Ms. Titus for her questions.
Thank you very much. I asked Mr. Gillums and Mr. Hearn 2 questions. First, we've heard a lot about putting these complex cases in these lanes, easy, medium, and hard. I understand the value of that, but I wonder if that's really effective, if that's not oversimplifying. Would we be better off to nuance it a little more than that? Are we really creating a system that's going to produce more errors down the road and contribute to the appeals backlog? That's my first set of questions. Second, I would go back to something I mentioned earlier, the rate as you pay. We're talking about complex cases. Would it not help veterans that as you rate some of the easier aspects of these cases that have a number of different problems, that veterans get paid for those as you rate them instead of waiting till the end?
I think the lanes process has worked. The field staff, they work for me, like it. They like being able to go to somebody who is ostensibly a specialist in that type of claim, whether it's in post-traumatic stress disorder, military sexual trauma, one of our severe disability cases. So it has worked. It really depends on the people, though. It really depends on how it's managed, and that can vary from regional office to regional office. Every regional office is not doing the wrong thing. A lot of them are doing the right thing. It's the ones that we hear about, though, that where it doesn't matter what process they have in place. If the people are inadequately trained, the greatest process in the world won't help them. To your question about the pay-as-you-go, I think that for veterans who just need relief, they need some resources. It might be okay. My fear, though, is that when you pay a veteran, let's say a veteran gets that 100% rating, the mentality will be, you got your 100% rating, what more do you want? We got you that, why are you coming back to us? Or that's going to be counted as a completed claim. I mean, how do you monitor the completion of that claim? If a veteran's 100% and getting a check, there's still a lot of work that needs to be done in our cases, but we'd have to make sure there's no creeping standard where if they're getting paid, that kind of sits on the back burner.
Mm-hmm.
This past year when we were going out and doing those trips for the FDC, and we visited to include the one where we visited in Reno, we did discover that it did bring some order to the regional office by having those segmented lanes. One of the things, though, that when we went out there, I would ask employees different questions, and one of the ones was, how much experience do you have? And it was overwhelming. And I would talk to coaches and some more middle management, to senior staff, and then talk about the relative greenness, I guess, of the staff at that regional office. Now, I've heard senior leadership from VA say on repeated occasions that, well, the effects of the Niemer case and the increase in claims due to Niemer has affected the backlog, and then we've heard conversation about 9/11 and the increase in cases from there. But the one thing that nobody seems to discuss is that you can't beat back the hands of Father Time, and that we've now hit an era in this country where baby boomers are retiring in larger numbers. Now, we didn't go back and they didn't balloon the VA, I guess, at the time when they should have. And so now you've got this knowledge vacuum, I guess, in the regional office. So there just isn't that much, there aren't enough people, A, but B, there's not enough experience there. So it's, yes, it does help, but I think a lot of it, too, is that they just simply don't have that much experience within that regional office. And then to go to the rate as you pay, I do think that it would be beneficial if you think about the effects that you could have if let's say somebody's trying to get service connected for 3 or 4 conditions, and you can get them to the 50 or 60%. Now they've got access to free health care through VA. In this age of ACA, that's a very good avenue for them. I also think that it also, in the cases of preference for federal employment, when it comes to issues dealing with VA mortgages and not having to pay the funding fee, of course these are important, and also you're getting money into the veteran's pocket. And so I do see the benefits. I agree there probably are some concerns that we should look at as to how VA would monitor this and make sure that cases and claims aren't just being set by the wayside while other things are occurring. But it is something worth considering, I think.
Thank you.
I'd like to add something.
Thank you. Is that all right, Mr. Chairman?
It is the policy of the VA that when it has enough evidence to pay partially, it pays. The problem is that the workers don't get any work credit, and therefore they're not encouraged to do it.
Right.
And we find many, many cases. So it's not a matter of VA policy, which says when you have enough evidence and the veteran should be service connected, pay them at this level, and then when we get more, we'll, up it. They want to take the time to do it because they are measured by how many cases they do, which gets back to my point of the work measurement system and Sherman's point that if you give somebody something, maybe he will go away, is the thought, and we won't have to, or she, and there won't be any more to do. So they really want to get rid of the case at that point. Thank you.
Thank you.
Thank you, gentlemen. Mr. Michaud?
Thank you very much, Mr. Chairman, and Madam Ranking Member for having this very important hearing. Information that the VA has provided us recently suggests that simply breaking out the workload into what they call those segmented lanes resulted in a 10% processing increase during the first 60 days. Also, easy claims saw an increase in timeliness of 100 days faster than the special operation claims. However, we know that VA continues to do a poor job in handling some of our most challenging claims. As the VA OIG noted in their testimony, in their first round of inspection, 31% of the TBI claims reviewed showed that staff had made errors. After informing staff of errors and VA taking action, the VA OIG returned to note that 29% of TBI claims reviewed were found to be in error. And you look at 12 of the 20 offices reviewed were non-compliant with the VBA's own policies for 2 consecutive inspections. They also noted that even after extreme simplification of PTSD claims, 5% of these claims are still incorrect. In my mind, the facts speaks for themselves, that we need to take the segment of lanes a step further by creating a few specific, specific offices that specialize and focuses on complex claims like TBI and PTSD and MST. These office needs specialists that are aligned and cross-functional teams, but focused and trained in extremely complex cases. I believe that most of you at the table support H.R. 2088 that would create a Centers for Adjudication Excellence. And my question, I'll start with Mr. Gillum. In your testimony, you articulate the problem with underqualified individuals handling complex claims. In your opinion, would we be better off if we specialize in these complex medical conditions? And the other two panelists can answer that as well.
I don't remember how I characterized it, but I think it's less about qualification in some of the cases I've seen and more about the rules that constrain their ability to make judgments using the experience that they might have accumulated over the years. The rules are just different. So even in cases where you've got somebody who is qualified, the rules are different. The rules say you have to do these steps. You can no longer exercise common sense. If it says hospice, and common sense says that that's probably skilled care, you still have to ask for an exam. Otherwise, the rating stands. That's a wrong rating. It's an inaccurate rating. And so that's where you get an error in that case. You don't exercise reasonable doubt. That's an error. You have to exercise reasonable doubt when the evidence is in equipoise. And they don't do that. So that's an error of law. So it really depends on convergence of both an inexperienced core of new raters as well as raters who have the knowledge and experience who don't have the freedom to exercise that judgment when it's necessary. And if you were to, sort of compartmentalize that knowledge, it really just depends on how you run it. If they're allowed to exercise that qualitative, deliberative thought process as they look at these claims in these compartmentalized centers of excellence, then it would work. But I don't think that's necessary. I think you could do the same thing with your special ops lanes, but just give them the ability to think and make decisions, exercising good judgment versus having rules dictated as a quality review standard.
Mr. Abram.
Thank you. First of all, I think the essence of fairness is time. If we set up lanes and they're pressured to go real fast, it won't matter if they're the most knowledgeable people on the planet. They'll make errors. Secondly, you're taking the veteran's claim away from his local representative. The American Legion or other service organization representative in Boise, Idaho, is not going to have access to the file or deal with the raiders if the case goes to Denver. I'm making that up, but that's a problem. In any case, until you fix how they count their work, these are fixes that sound good on paper, but aren't going to make a major impact. That's the first thing to do. It sounds great, but I also worry that if people are trained to deal in SMC and that's all they do, then the rest of the VA raiders are not going to know SMC unless they're trained. They'll only have a small component of people to do it. There's a lot of pros and cons into it. It's worth a try if we can also implement some way to give them the time to do it or to hire a lot more people to help. I keep saying that, a lot more people. Thank you.
Thank you. Generally speaking, like Ron had said, the American Legion favors the idea of local adjudication for claims. I think what you're saying, though, is that you're essentially going to create a workforce of warrant officers where they're specialized in particular areas. And this is the thing that I kind of question. If you're a high-performing regional office and you're assigned special monthly compensation and then you're working in a different office and you're assigned something that's a little bit easier, say like tinnitus or something, what's that going to do to the morale for the people working in tinnitus? I mean, I wouldn't feel too good for myself if they say, well, this is all they think of me, I'm stuck with the tinnitus gang. And so I don't think that that's necessarily the way that you want to go about it. I think that you have to have a comprehensive approach to training and evaluation. I was speaking earlier in our office about it. I said, if you, 10, 12 years ago, when you passed No Child Left Behind, the big concern in the education community was, well, teachers are going to start teaching to the test. And that's what some of these evaluations do. When they're looking at their STAR team reports, it's a checklist. And Congresswoman Titus could attest to her years in academia. You don't want to test somebody's knowledge on multiple choice exams. You want to test them on blue book exams, because that's comprehensive understanding. And that's what our big concern is at the American Legion. Thank you.
Thank the gentleman, and thank all of you today for your testimony and for the work you do on behalf of disabled veterans. You are now excused from the witness table, and we'll ask our third panel to come forward. This will be our final panel today. We welcome Mr. Tom Murphy, Director of Compensation Service with the Veterans Benefits Administration, also Ms. Edna McDonald, who is Director of the Nashville Regional Office, accompanying Mr. Murphy today. We also welcome Sandra McCauley, Deputy Assistant Inspector General for Audits Evaluations with the Office of the Inspector General, Department of Veterans Affairs. Ms. McCauley is accompanied by Mr. Brett Arante, Director of San Diego Benefits Inspections Division. We appreciate your attendance today. Your complete and written statements will be entered into the hearing record. And Mr. Murphy, you are now recognized for 5 minutes.
Chairman Runyon, Ranking Member Titus, and members of the subcommittee, thank you for providing me the opportunity to discuss the VA's policies and procedures for adjudicating complex disability claims. I'm accompanied today by Ms. Edna McDonald, Director of the Nashville Regional Office. The VBA continues to experience an increase in the number and complexity of medical issues. Between 2011 and 2013, the average number of issues in original claims increased by 31%, from 5.5 to 7.2. In response, VBA developed and implemented a new operating model. VBA has noticed an increase in complexity of the claims from the newer generations of veterans who participated in operations Enduring Freedom, Iraqi Freedom, and New Dawn. These young heroes have a greater chance of surviving serious injuries and often return home with multiple serious conditions. In addition, VBA continues to receive complex claims from veterans of the Vietnam era. Many of these become complicated because they are subject to federal court orders in the Niemer versus U.S. Department of Veterans Affairs. The new organizational model incorporates cross-functional teams working on one of 3 segmented lanes: Express, Core, and Special Operations. Lanes were created based on complexity and priority of claims. The Express lane develops and rates claims with a limited number of issues and subject matter which could be developed and rated more quickly. Core lane includes claims with 3 or more medical issues that do not involve special populations of veterans. The Special Operations lane applies intense focus and case management on specific categories of claims that require special processing or training. It's comprised of a regional office's most highly skilled personnel with specialized experience and training. VBA is simplifying ratings by building new decision support tools to make our employees more efficient and their decisions more consistent and accurate. One of them is the Evaluation Builder and is essentially an interactive rating schedule. The rater uses a series of checkboxes that are associated with the veteran's symptoms. DBQs are another tool designed to simplify rating decisions. They replace traditional VA exam reports and capture all needed medical information up front and present the findings in a rater-friendly format. Claims are considered complex for a variety of reasons. Here are 3 examples. Due to the complexities of rating TBI, the Special Operations lane processes these claims. Since March 2013, all raters in this lane are required to complete specialized training. This web-based module is 22.5 hours on how to rate a claim for the residuals of TBI. Due to the myriad of symptoms that a veteran with TBI may experience, it is often unclear which symptoms are solely attributable to TBI In October 2011, Compensation Service provided guidance that examination findings should be related to the veteran's TBI condition unless such symptoms are clearly attributable to other causes. In addition, VBA has instituted safeguards to ensure consistency and accuracy. All raters are required to obtain a second signature on TBI claims until the individual demonstrates 90% accuracy in rating such claims. As a result of these efforts, VBA has seen TBI grant rates increase from 21% in 2007 to 47% in 2013. Further, the accuracy of TBI ratings during fiscal year 13 was 92.37%, slightly higher than the national average for all rating claims during the same period. Service connection for PTSD requires three things: medical evidence diagnosing the condition, an in-service stressor, and a nexus connecting the two. In 2010, Secretary Shinseki made it easier for veterans with fear-based PTSD to establish service connection. VA added a regulation providing that a veteran's lay statement alone can now establish the required in-service stressor. VA provided extensive training on this regulation change to ensure consistent and accurate ratings. MST-based PTSD claims are processed by the Special Operations Lane as well. Complications generally arise in situations where there is no corroborating evidence of the stressor in the veteran's military records. In these cases, VA must notify the veteran that the evidence from outside military records may be used to support the claim and must attempt to obtain any such evidence identified. In 2011, VBA conducted a quality review of 400 MST-based PTSD claims, which found an approximate 25% error rate based primarily on incomplete development. We developed and implemented an MST-based PTSD training package. It emphasized the proper evidence development and recognition of the types of evidence. Following the training, the MST-based PTSD grant rate rose to a level comparable to that of other types of PTSD. VA has seen a significant increase in the complexity of claims received in recent years. To address this trend, VA implemented a new organization model with a special operations lane focusing on complex disability claims. This concludes my statement, Mr. Chairman. I would be happy to entertain any question you or members of the subcommittee may have.
Thank you, Mr. Murphy. With that, would recognize Ms. McCauley.
Mr. Chairman and members of the subcommittee, thank you for the opportunity to discuss our work regarding complex disability claims processing issues. With me today is Mr. Brent Arante, Director of our San Diego Benefits Inspection Division. In addition to our nationwide audits, the OIG reports on individual VARO effectiveness in providing timely and accurate benefits and services to veterans. Of major concern, however, is continued VARO noncompliance with VBA policy, despite our recommendations for addressing issues we identify. Specifically, in response to our May 2011 report, VBA began requiring second signature reviews of all TBI claims until raters demonstrate 90% accuracy in TBI claims processing. However, in FY 2013, we saw only slight improvement since our first cycle of inspections. 12 VAROs remained non-compliant in processing TBI claims for 2 consecutive inspections. Half of the errors were due to VARO staff using inadequate medical exams to rate TBI claims. In January 2011, we projected VBA incorrectly processed 15% of 100% disability evaluations for about 181,000 veterans and paid a net $943 million without adequate supporting medical evidence. VBA implemented training and internal controls to address this issue. However, VBA repeatedly delayed completing its review of all 100% disability evaluations to ensure each had a future examination date entered in the electronic record. Our second cycle of VARO inspections continued to show a high error rate in processing these evaluations. In most cases, errors occurred when staff did not enter suspense diaries in VBA's electronic system to request medical reexaminations as required. We continue to review VBA's systematic analyses of operations, SAOs, and organized means of reviewing Veteran Service Center VSC operations to identify problems and propose corrective actions. We found 6 VAROs remained non-compliant in this area for both cycles of our inspections. Generally, Vero management did not provide adequate oversight to ensure SAOs were timely and/or complete. We noted a correlation between SAO noncompliance and Vero's having vacant or temporary director or VSC manager positions for 5 months or greater. Currently, we are assessing VBA's initiatives to improve claims processing and eliminate the backlog. We are reviewing the initiatives VBA began on April 19, 2013 to process within 60 days all claims over 2 years old. Of note, we determined 10 of 11 provisional rating decisions at the Los Angeles Vero were non-compliant with VBA guidance. We found the Vero Director's Office had emailed conflicting guidance to staff requiring provisional ratings without supporting medical evidence. Concerned that additional errors may exist, we recommended that VBA review for accuracy all 470 provisional ratings completed by the Los Angeles Vero after the conflicting guidance was issued. Findings from our ongoing audit of the Veterans Benefits Management System, VBS, suggest some progress. While VBA has reduced its inventory and average days to complete claims, we cannot determine if the improvements are related to VBMS or other transformation initiatives. Moreover, VBMS continues to experience performance issues, and users rely on legacy systems to fully process claims. We have initiated a review to determine the extent to which VBMS helps VBA improve the accuracy and consistency of its claims rating decisions. We expect to report our findings in early 2014. In conclusion, VBA has made some progress but continues to face challenges to improving claims processing accuracy and timeliness. Inefficiencies mean not only added burdens and delays for veterans, but also improper payments that VBA will not likely recover. We will continue to look for ways to promote improvements in VBA benefits delivery during our future audits and inspections. Mr. Chairman, this concludes my statement. We would be pleased to answer any questions that you or other members of the subcommittee may have.
Thank you, Ms. McCauley, and begin a round of questions with myself. And first question, probably for Mr. Murphy and Ms. McCauley, I'll have you both kind of touch on it, and it precisely touches on one word here, accuracy. Mr. Murphy, VA uses the term accuracy frequently. Today we've heard from veterans, representatives of veterans, VSOs, and VA Office Inspector General who indicated that claims are not being correctly decided at very high incidence. The files lack proper development and the medical examinations are not adequate. VA OIG noted that RVSRs are not consistently returning adequate medical reports to VA facilities as required due to pressure to meet production requirements. In a moment, I would like you to explain in detail how VA calculates and represents a 91 claims-based accuracy. I find VA's representations of accuracy to be even more concerning when you state that VA's TBI accuracy to be over 92%. VA OIG, who is specifically tasked to perform quality reviews of TBI claims, reports that over 30% of cases nationally, employees are not compliant with VBA policy, with individual ROs showing error rates as high as 50%. So here's the question. Does accurate by VA standards mean that the veteran received the correct rating decision for the claim conditions upon full and proper development of the claim? And if accurate indicates anything less than this, what does it mean?
Accuracy means exactly what you said, Mr. Chairman. Did the veteran receive the proper benefit entitlement payment or decision in the case of a denial? That's the measure of accuracy conducted by our quality analysis staff in Nashville and reported out. That's what the 91% means. That number is drawn from a true statistically valid nationwide sample, random sample applied to all regional offices, collected into Nashville each month, evaluated, returned to the regional office, and then summed up on a rolling 12-month average.
Why do we have a discrepancy with the OIG numbers, though?
The IG and VBA don't measure what an error is exactly the same way. I look at an error is, did the benefit entitlement be wrong, number one, and then the VIG tends to look at it from the standpoint of, Did you follow the process? If you varied from the process, but you got the benefit entitlement decision right, I will not call that one an error, however the IG will. But there's something more important that you need to hear, and it's a quote from the IG report, which says, "We sample claims we consider at higher risk of processing errors. Thus, these results do not represent the overall accuracy of disability claims processing at this VA regional office." This is a page from the title of the IG report. There's one of these in each report. My point is this. The IG, by design, targets a specific subset of known high errors. If you take that number and extrapolate it out to say the entire regional office is this way, it's not an accurate representation of the sum of work for that regional office. I'm not disputing that it's an accurate representation for the subset that they looked at, but not for the totality of work that comes out of the regional office.
No, but I'm having the discussion, but we've also broke it down to just TBI cases, and your numbers conflict there.
Yes, our numbers conflict there. The IG's reports that you're looking at here are a sum of several years' worth of work. The numbers I'm giving you are a sum of the last 90 days' worth of work. My point is this. When you look at current where we were and where we are, the IG report is much more reflective of where we were, not necessarily where we are sitting right now today.
Ms. McCauley, can you respond to that?
Yes, the numbers for TBI that we reported, they were the 31% accuracy, error rate. That was based on our first round of inspections from 2009 to 2012. More recently, we found a 29% error rate, and that was for our FY 2013 inspections. As Mr. Murphy suggested, we do look at specific high-risk types of claims, and so we're not looking across all the different kinds of claims to come up with an accuracy rate, but rather to focus in on those such as TBI or temporary 100% disability evaluations that have shown repeatedly to have a high error rate. Also, there is a big difference in terms of how we call errors and how VBA calls errors. We don't focus just on the benefits entitlements amount. When we look at the claims, we look at the processing of the claim, human error, system error, processing error, did they follow regulations? All of that goes into the accuracy of a claim. Sometimes the benefits entitlement might be correct for the moment, but sometimes there are errors that are made that could have potential impact on benefits down the road, future benefits for the veteran. So we look at the totality of the claims processing exercise.
One more question. Talking about how you compile statistics, does the VA keep track of accuracy and appeal rate by the number of years of experience by the RVSR or the DRO?
Track of it from the standpoint of I can go back to my office and give you a report that says this. No, I don't report it out that way on a routine basis. However, in determining the training that we're doing, the types of training that we're doing, where we're spending our effort, where the errors, the high concentration of errors are, I use that data every single day to determine exactly what training I need to be doing, where I need to be concentrating it, even down to the regional office level. And by tracking and looking at errors at an issue-based level, which we started doing more than a year ago at this point, I now have the ability to go in and say, TBI is a high error rate in a particular regional office and target just the raters that work TBI, as an example. So to go back to the office and give a report and say, here it is, no, I don't track it that way. However, in all of our training process and everything else that we do, that information is considered on a regular basis.
But where my head is on this is it because of a lack of experience at some level? It came up in the last panel that maybe we don't even have enough people with the experience to be able to rate these things. Is that trackable in your statistical analysis?
Let me go back to your first question, Mr. Chairman. This is an excerpt from the Waco report. It talks about traumatic brain injury, reviewed 30 cases. Cases in error that affect veterans' benefits, 0. Potential to affect veterans' benefits, The difference of rules between how the IG looks at it and how I look at it is 8 out of 30. There's the 30% error rate that you're talking about. Did the veteran receive the right check based on what they had? Yes. Was there maybe a process that's done different, but they got the right benefit entitlement check? Yes. An error in the IG eyes, but when you look at that from the veteran focus, that was the right decision and the right compensation was received by that veteran.
We always have, what I'm just trying to ask, is it possible to find the analysis of, does someone that has more experience in, say, a certain regional office has more experienced personnel in it? Are you getting a better outcome there?
Are we getting a better output in the...
With experience of the claim adjudicator?
Yes, you are. No question.
You track that?
We track that. In fact, we did what we call a consistency study the first week of August. And we broke it down with 6 questions that were sent out to all people. This one happened to be on, I think it was diabetes, yeah. And what we did is we broke it down by lanes, we broke it down for the quality review teams, for the STAR staff, and I laid all of the different segmented populations of work lanes. And by a long shot, meaning in the mid-high 90% range, the special operations lane got those questions right at a much higher percentage, at the 93, 94% rate, where the average for the total population was in the mid-80s. The point being that the higher experience level, the better education, the more training that we're doing with those individuals is yielding better results, more consistent results of higher quality. At the same time, we're concentrating those more trained, more experienced people on the most complex conditions that we're dealing with.
If at all possible, I'd like to have staff be able to reach out to you and maybe take a look at those numbers.
Yes, sir. I'd be happy to provide.
Appreciate that. And recognize the ranking member, Ms. Titus.
Thank you, Mr. Chairman. I'd like to look at those numbers too. If we can get them back, try to get some sense of or some order to them. Mr. Murphy, I've been talking about pay as you rate a good bit today because I think it fits in with this notion of the 3 different lanes and how to deal with complex cases. And we know that the VA has the authority to do pay as you rate. And I wonder if you would talk about that, talk about what the problems are of why you don't use that more often. And is this a problem that we can address of how you compensate the people who make these decisions based on a full claim decided or a part claim? Address some of the concerns that were brought up in the previous panel about it.
Okay. The previous panel brought up comments about you didn't get work credit for it, so it wasn't worked.
Right.
Without going down and saying, yes, that's right, no, that's not right, let's take that as a base to talk about what we're putting in place actively right now, which is exactly what you're describing. If I receive a claim from a veteran that's got 10 issues on it, I need to break that down into 10 issues and have maybe one rater rate 10, maybe have 10 raters rate 1 each. But the point is this. Break it down into 10 individual issues, make rating decisions on those 10 individual issues, and compensate the veteran if they're entitled to it as those rating decisions become, as they're made, and we move forward to do the others. The problem with that is in the system we're working with right now today, that's very difficult to do. And there are some barriers in terms of it's much less efficient in the amount of time that it takes our overall process to rate 10 individual issues at 1 each. The fixes that we're putting in place will allow that to go significantly faster, and then our intent is to do exactly that, which is rate by issue. And so yeah, we understand what's in your bill. We've testified on that previously, that we agreed with that bill in concept. But at this point in time, there were some complications due to our system limitations.
Well, when do you anticipate that those changes will be made?
I can't put an exact date on it for you, but what I can tell you is every 90 days we do a new release at VBMS, and I'm not sure which one of those releases that some of these changes are in. One of the changes that is going in that's being piloted right now in one regional office is the VBMS-A, or authorization module, and we need that in place in order to help these individual issues as they're decided to move through the system quicker. In other words, when I have the VBMS authorization module in place, I'll be able to process these individual issues without impacting the total system time.
And will there be safeguards in place so that you don't just pay a veteran off for a few things and think he'll go away, as opposed to really do complete the entire
Yes,
complex
we're looking
claim?
at breaking this down so that it comes in as a single claim, but it's posted in our system, and we track it as though they're 10 individual claims. So this isn't just I'm going to receive a claim and then I'm going to break it up and process by issues. This is a true issue-based tracking, issue-based reporting, issue-based quality, everything.
I know that some of the cases that are in the Reno office have been farmed out to other offices where they can be moved faster and stuff like that. If you start breaking a claim down so some of the things are easy and some are more complex and you end up in 2 different lanes, you're not going to end up in 2 different places, are you, to have your claim completely considered?
Well, depending on Mr. Michaud's question just a little while ago about centers of excellence, we certainly need to consider whether those 2 different issues that are in 2 different lanes even need to be in the same regional office. Why, if we go with the concept of centers of excellence, and Detroit happens to be on issue number 1 and St. Petersburg issue number 2, why would we not send that claim? Because it's seamless now, and once I have an electronic environment, I can move them around the country by just a few keystrokes. So we still don't have the final, this is exactly how it's going to be, but we're exploring the options from how do I get it through our system right and fast.
Mm-hmm. We just don't want to make it more difficult for a veteran to be able to track where their claim is or understand what's happening with it and when it's happening by scattering it around or making it more complicated.
Yes. And you're seeing that. One of the information points I'm sure you're interested in is the number of cases you currently have broken out from the Reno office.
That's right. We're waiting for some of those answers.
It's just under 700 right now. And you've heard what we are doing with the 2-year-old claim and the 1-year-old claim, and now moving to the 334 days. If the capacity of a regional office isn't in place in order to meet the timelines that we're putting in to meet these different deliverables on the oldest claims, we're shipping them off to other regional offices. In other words, we're making the oldest claim issue a national problem and not one tied to a particular regional office. So it just so happens that in Reno today, they happen to have a large number of the older claims, so we've sent those to other regional offices that have capacity to get those veterans done in a timely manner.
Thank you.
Thank you, gentlelady, and recognize Mr. Michaud.
Thank you, Mr. Chairman, and I want to thank this panel as well for your testimony today. Mr. Murphy, VBA currently adjudicates claims related to Camp Lejeune in Louisville, Kentucky, and claims related to radiation in Mobile, Alabama. Can you explain to the committee why this is?
Well, those claims actually fall under the title of this hearing. They're complex claims. They're highly complex claims. And what we don't want to do is we don't want to have a veteran, because they went to Regional Office 1, get one decision, and the equivalent case go to Regional Office 2 and get a different rating decision. So in order to do that, in order to concentrate our efforts, and because of the way we were doing claims in the paper world, we concentrated them in single places. We provided special training for the processors and raters that worked the claims, and then at the same time we went back and worked with BHA and provided training to the individual CMP examiners that would be working these particular types of conditions, and then fed them back to a single jointly trained rating board so we get a consistent, accurate output.
Yep, so those 2 areas are specialized in those particular.
Absolutely. Okay. Yes.
For the OIG, Ms. McCauley, throughout your inspections on these difficult medical conditions, how often is training and a lack of knowledge regarding policies and procedures is a problem? How often is that?
It certainly has shown itself to be a problem as a result of our inspections. For example, in TBI, it's been said repeatedly today about the complexity of the policies for rating TBI claims. And we did find that the additional training was needed in the TBI area for the raters to be able to rate claims correctly, especially with regard to the issue of inadequate medical examinations, making sure that they return them to the medical practitioner so that they get the adequate information they need to rate those claims.
Okay. In consideration of your response, do you think veterans would benefit from having teams where specialty that are specially trained and focused on complex conditions such as TBI, MST, and PTSD, similar to what we just heard Mr. Murphy mention about Camp Lejeune and radiation in Mobile, Alabama?
Well, we haven't examined the issue of the specialized lanes, but certainly additional training would be a help in terms of adjudicating those claims.
So the better trained, the better specialized the workers are and the work that you have done, the more accurate they can, and timeliness that they can process those particular claims.
We would expect that, yes.
Great, thank you. Mr. Murphy, just to follow up on my previous questions about Camp Lejeune and Mobile, Alabama, where you specialize in those particular areas. One of the problems I've seen over time being on this committee is, and particularly in some regional offices, where the error rate is, over, as you heard the chairman, over 50%. When you look at the turnover rate in those areas, they might not be an employer of choice, and you're constantly training individuals, and particularly with our veterans coming back from Iraq and Afghanistan with TBI and PTSD and MST issues. I think it's important that with the new VBMS system, I like the idea when you're looking at the medical conditions, because with the medical conditions, you can move that anywhere around the country in a timely fashion. So if there's a certain regional office that is specialized, such as Camp Lejeune in Louisville, Kentucky, to deal with those issues, that they can get an accurate decision in a timely manner. I understand some of the concerns that some of the VSOs might have, that it's not all done in the regional office. Well, it's not done anyway. When you look at a lot of the cases that are being brokered to other areas because they are not performing adequately, I'd like to just, see whether or not you would really consider looking at, centers of excellence for those very complex cases, since you can move it electronically once the VBMS system is up and completely running fully.
We would consider the centers of excellence concept. In fact, my staff is going through now, pulling numbers in terms of accuracy, rating capacity, et cetera, on regional offices right now to identify, are there some clear outliers that say, this should be a COE for PTSD. This one should be for military sexual trauma. This one should be for TBI. So we're going through that process now. We're just beginning that process. It's not quick. It's going to take some time to do to make sure that we get it right. But if there's some centers of excellence that are doing it right out there now, there's some lessons for it. Number one is, should I make them the center for all over the country? And number two, if the answer is no, I should not, then what are they doing different to get it right that I need to teach the other regional offices? So either way it goes, this analysis that we're doing is going to yield good things for us. Back to the other part of your question, which was the VSOs having some concern about the not being able to have that interaction and look at the file and review it. In the paper world, that was a problem. In the electronic world, with the stakeholder entry portal we have in place and the very shortly coming up releases which will allow them to see much more of the claim file and the decision that's being made, they'll be able to perform that review from anywhere in the country, regardless of what regional office is working that file.
I appreciate that answer, because for me, I think our number one priority should be making sure the veteran is taken care of, not whether or not the claim is processed in the regional office, particularly if that regional office is not performing the way it should be. So thank you very much. Thank you, Mr. Chairman.
Thank you, gentlemen. And I actually have another question. I know Mr. O'Rourke's going to come back. So, Mr. Murphy, your testimony highlights that VBA has improved policies and procedures to ensure more timely and accurate decisions to veterans with complex claims. Setting aside the discussion we just had about strong concerns on how VBA calculates accuracy, VA's work towards better policy and procedure is welcome, but what the committee is hearing from the IG is that your regional officer are repeatedly failing to comply with the policies that are in place. To auditors, directors, and managers, this can be a theoretical exercise, but to the veteran who is underrated or denied because a regional office is non-compliant, this is a complete failure. And as I read the American Legion's testimony, for those, and it's quote, for those veterans, VA's accuracy might as well be zero. The Inspector General consistently reports that the need for policy guidance, oversight, training, and supervisory review, and yet 17 of 20 recently inspected offices remain non-compliant with VBA policies, most of which were found to be repeatedly out of compliance. How are you going to enforce compliance, or to put it another way, what will be the penalty for non-compliance?
I can't answer directly your question on what will be the penalty for non-compliance. That falls under the Office of Field Operation and Deputy Undersecretary Rubens. However, I can tell you what we're doing to ensure compliance is happening. And the solution is not going out yelling at regional offices, directors, and telling them you must follow the process. The solution is for me to put a system in place which takes them down that path, and the right way becomes the path of least resistance. An example of how we're doing that today is, number one, I talked about how we changed the rules around PTSD, so we no longer had to go away and make a determination about the stressor and get a buddy statement saying what happened. We changed the rules so that if the veteran came in and said I was in fear for my life, they served in a hostile environment, you order an exam and you assess them for PTSD. So that's the way we handle it from the rule side. When I look at it from what system am I putting in place to ensure at a grassroots level, I got to take us back to the temporary 100%. And the example there is in the system we put in place with VBMS, you can no longer just hit a button and move through a screen. You're forced to stop and put a routine future exam date in place and place that item under control before the rater is allowed to push the button and move to the next screen. The point is, I forced the behavior without having to go out and push and discuss and come back and re-examine. I know that it's happening because I can track it and I can see it on my system, and I pull a report every 2 weeks. And that every 2-week report, last year I was seeing 600 cases. Now I'm seeing 50 cases. And the reason for that is today there's somewhere in the neighborhood of 75% of our cases are electronic through VBMS. We're still working through the last of the paper. So as we move to the electronic environment, the compliance rate will go up, and then I'll see that number drop over time. So the answer to your question is I fix it by putting procedures in place that drive the RO in the right direction, and I put system fixes in place that force the behavior that we need to have to ensure the veteran gets the right decision.
And before I yield to Mr. O'Rourke, I would remind you and remind everybody how many times Secretary Shinseki has sat there and talked about accountability and how are we going to hold people accountable. And that's ultimately where we have to get to. You can do all the systematical stuff you want. If you're not motivating people to do it, I know they're highly motivated people. They want to do right by the veteran, but there's a lack of accountability there, and it's across the board. But with that, I'll yield to Mr. O'Rourke.
Mr. Chair, thank you, and I apologize for missing part of the second half of the hearing, and I'll get an update from those who were here about how you responded to some of the specific issues raised by Ms. Price and Ms. McNutt and the veteran service organizations that were here. So just briefly bring up 2 issues. One is in El Paso at Fort Bliss, we have 1,800 IDES cases. 1,100 of those are backlogged at the DRAS site in Seattle. And so just a plea from Colonel Heimel at William Beaumont, from us in our office representing those soldiers, whatever you can do to provide additional attention and focus on that so that we can get those folks through there. We have some associated problems with our wounded warrior transition unit there, and part of that is having these folks who are in this backlog, this bureaucratic loop. The second one, Ms. Price mentioned that she filed a fully developed claim and took us through every part of what she went through to do that. We've been pushing for fully developed claims filed online. We think that through things like the Faster Filing Act and other initiatives that have come out of this committee, we can cut the wait time, which in El Paso right now for a typical veteran is 450 days out of the Waco Regional Office, down to something like 100 or less. So I want to just pick up on what Ms. Price said, and I want you to address the concern that raised with me and others that there may be a problem with fully developed claims and our ability to process them in a timely fashion and do so accurately.
Let me start with IDES. Since we understand exactly what you're talking about, and with Fort Hood and Department of the Army in particular.
Fort Bliss, sorry.
Yeah. Fort Bliss, and we put some definitive actions in place that you'll see the numbers at that regional office, that DRAS site, start going in the right direction. First of which is in April, all of the employees at the Seattle D1 BC, Day 1 Brokering Center, we shut down the Day 1 Brokering Center and rolled it into the IDES site. What that does is it gives them immediate trained capacity to go in and start working IDES cases. Two, in May of 2013, we hired an additional 36 raters in that regional office. Now, that sounds like, oh, they've been there since May, but the reality is they just started working last month because they just completed challenge, and now they're in production working in the DRAS working cases. In May of 2013, Army Reserve personnel were activated and deployed to Seattle to help the DRAS site in getting these IDES cases through quicker. Staff at the regional office has been working mandatory overtime from mid-May to November of this year, and right after the holidays, they will resume mandatory overtime through 2014, provided the funding is available to us. One other item that we've done with that is we had capacity in Providence to take some of those cases because they're working faster. So 250 cases per month are being brokered to Providence in order to help take some of the pressure off of the DRAS site in Seattle. So I think in the coming months you're going to see drastic changes in there. One other comment about the IDES process in general. To look at the IDES process and say it's merely a simple claim is to call a complex it's merely a complex claim is to call a complex claim a simple one. My point is this. These are the most complex of complex cases for veterans that are still serving. They take additional care, they take additional requirement, and they take joint cooperation between the VA and the Department of Defense. As a result, a timely claim going through the IDES process is measured at 295 days, not the 125 days like we see for the traditional rating bundle. The second part was about Ms. Price and the FDC, and I guess I'm not sure exactly what it is that you're asking me there, Congressman.
Well, I guess the concern was, and I apologize again, I've missed almost everything that you've had to say in response to the stories that we heard earlier, so you may have already answered many of the concerns raised, but one of those among many that were raised was that Ms. Price, I believe before transitioning out, had already prepared and filed a fully developed claim, and yet she had this incredibly arduous, long battle to get that claim adjudicated in a satisfactory way. And so it causes concern for me and others when we're trying to direct veterans to file those fully developed claims online, and we're telling them that they can get those claims resolved in some cases, or in I think the majority of cases, close to 100 days versus the average in El Paso 450 days. A story like Ms. Price's gives me some pause, and I just want to know whether that is truly exceptional or whether there is more to that. And she seemed to indicate from other veterans that she had met with and has assisted that she's seeing similar cases to hers. And so just wanted to get your quick feedback on that. And again, if you've already answered it or you'd like to answer it in more detail at a follow-up meeting, I'd be happy to meet with you then. But if you could just quickly talk about how exceptional a case like that is.
I have to stay off discussing an individual veteran and that veteran's circumstances, but what I can tell you is this. Based on the time frame that Ms. Price submitted her claim, 2009, when we were receiving fully developed claims at less than 2%, to today we're receiving 27% of those claims. They're going through with our highest priority, and they're being tracked and monitored on a national basis at a national level. So my point is this, the experience that she saw is by no means typical of the process you're seeing today when the claims are going through in 115, 120 days through the fully developed claim process. Other things that have happened is in the very early stages of it, we had a high rate of those claims that were entered into the fully developed claim process and for various reasons, right, wrong, or otherwise, were removed from that process and put through the normal channel. We track and monitor that routinely now to make sure that a fully developed claim that comes in maintains its path through the fully developed claim process. There are specific rules that will pull that claim out of that process. But now that we've put these control measures in place, it's not being used or abused it's not being used to the rate it was when the fully developed claim program was new.
Okay, thank you. My time's expired, Mr. Chair. I'll yield back. Thank you.
Thank you, gentlemen. Any members have any further questions? No. On behalf of the subcommittee, thank you all for your testimony. You are now excused. Thank everyone for being here with us today. Ensuring that our veterans receive timely and appropriate decisions regarding their service-connected claims is a top priority for both this committee and the department. It is unacceptable for the price that is timeliness to be the accuracy of those decisions, and we'll certainly be seeking more information in the near future on areas discussed as VA continues to march towards the Secretary's 2015 goals. I'd like to again once again thank our witnesses for being here today. I ask unanimous consent that members have 5 legislative days to revise and extend their remarks and include any extraneous material. Hearing no objections, so ordered. Thank the members for their attendance today, and this hearing is adjourned.